All right, Tony.
There's something
wrong. Tony, can you hear me okay? Where is Tony? Okay.
Okay.
Let's go ahead and start again. Sorry, Mr. Collins. Let's go on the record. I will just start over again. DC 216897, Quran versus Asamata. Council, make your appearances.
Sean Oslet, representing the plaintiff Sharzad Quran.
And Robert Collins, representing defendants Fred Asamoto, Walmart Inc. and Walmart Transportation LLC.
All right, let's proceed.
All right. Good afternoon, Your Honor. Robert Collins for the defendants. There are two motions before the court today. The first is defendants' no evidence motion for summary judgment. Just to provide the court very brief background, this is a disputed liability multi-vehicle lane change collision that occurred on July 15th, 2019. Suit was filed on June 1st, 2021. The lawsuit is currently set for trial in January 2023. And the discovery period in the case has closed. Defendant has filed a no evidence motion for summary judgment on plaintiff's negligence cause of action against defendant Fred Asamoto. We've moved for no evidence motion for summary judgment on all elements of plaintiff's claim, duty breach, and proximate cause. In response, the plaintiff has filed a response to that motion, and we have made and in that response, the plaintiff has filed as summary judgment evidence, unauthenticated medical records and medical bills, unauthenticated and uncertified Texas peace officers crash report, and unauthenticated photographs of the vehicles involved in the accident. Defendant has filed objections to that summary judgment evidence. I believe that the evidence that the plaintiff is using as in response to its summary judgment is both defective in form and substance. All of the medical records, all of the bills are unauthenticated and uncertified. In my objections, I cite the Cluis versus Kuchenbacher case, which is a 2003 case from the Fifth Court of Appeals, where it addresses summary judgment evidence and asserts that, just quoting the language here, as to the exhibits attached to Cluis's response to Kuchenbacher's motion for summary judgment, unauthenticated or unsworn documents or documents not supported by any affidavit are not entitled to consideration as summary judgment evidence. So 2003 decision from the Dallas Court of Appeals. I'd also cite to U.S. Flood Services versus Longoria, Texas Supreme Court, 1997. The procedures for a summary judgment are the same for a trial, so you have the same evidentiary standards. As it relates to the Fifth Court of Appeals, I did some additional research today, Your Honor. There's also the Gonzalez versus McKinney Dodge case from 2015. It's also an issue regarding summary judgment. And in that case, the Fifth Court of Appeals also affirmed the trial court's exclusion of the summary judgment evidence. They note that, quote, Gonzalez attached only unauthenticated documents to his response to the motion for summary judgment. Unauthenticated or unsworn documents or documents not supported by any affidavit are not entitled to consideration as summary judgment evidence. And then just briefly, Your Honor, the Fifth Court of Appeals just a couple of months ago in Constant versus Gillespie was talking about a arbitration agreement, but it said that the same standards that apply to arbitration motions to compel arbitration apply to summary judgment, and say simply attaching a document to a motion does not make the document admissible as evidence or dispense with proper foundational evidentiary requirements or relieve a litigant of complying with other admissibility requirements. And so my understanding, Your Honor, in making these objections is first that individually I'm objecting to the medical records and bills because they're defective in form, because they are unauthenticated and uncertified. I'm objecting to the crash report because it is unauthenticated and uncertified. And I'm objecting to the records because they are unauthenticated and uncertified. And then lastly, Your Honor, I believe that's also a defect in substance. My interpretation of reading the law today is I have to make the form objections to you to get the rulings. I don't think I have to make the substantive objection. At least that's how I read the case law, but I'm going to go ahead and make it. So I think that all of the evidence that was attached to the plaintiff's response is defective in both form and substance because it's unauthenticated. And there are other arguments that are in the motion, and I can continue to, that are objections, and I can continue to go on. But I mean, do you want me to go on, or do you want to handle them each, however you want to do it?
Let me hear from Mr. Oslot about this.
Okay. Afternoon, Your Honor. First of all, we feel that the no evidence motion for summary judgment should not be granted, merely because we've provided more than a scintilla of probative evidence to raise a genuine issue of material fact. We've going back earlier this year with regards to this case, we had some of the medical records available, but not all of them. And we produced the on May 5th, 2020, we produced the Texas Peace Officer crash report to Mr. Collins. Later on July 26th of 2022, we produced the final medical records as part of plaintiff's second supplemental responses to defendant's request for disclosure. In addition, we believe that that the plaintiff has raised a genuine issue of material fact through his affidavit.
So have you attached affidavits to your documents? Is that seems to be his main objection, and that's
yeah, we haven't filed the medical or the billing affidavits pertaining to we haven't filed the medical or the billing affidavits. We've only provided an affidavit from the plaintiff raising a genuine issue of material fact, an effort to save the summary judgment. But we have not produced any of the medical record or billing affidavits. But even though we haven't, even though they're not authenticated, we still feel that summary judgment evidence doesn't need to be presented in an admissible form up until trial, or the court can further consider that it may order a continuance to permit affidavits from being presented.
So this is your response. We attached
both responses, the initial response supplementing part of the medical records. And then in July, we produced the remaining medical records. And I believe that's when the summary judgment was filed. And we're currently going through discovery. We have not even done, my client hasn't even been deposed yet. And he produced an affidavit last week stating, "My name is Shirzad Kuram. I am of sound mind and capable of making this statement. Have personal knowledge written in the statement. I understand if I lie in the statement, I may be held criminal liable. I, Shirzad Kuram, do hereby swear under oath July 15th, 2019, while I was driving westbound 3000 block North Stemmons, Mr. Asamoto, while driving in a tractor trailer owned by Walmart Transportation, while also driving westbound on the 3000 block of North Stemmons, unsafely merged into my lane, causing the collision. But for this collision caused by Mr. Asamoto and Walmart Transportation LLC, I have accrued economic and medical expenses, economic damages and medical expenses." So we've produced everything to counsel, to defense counsel, even though if there's an issue with regards to authentication, we do feel that summary judgment evidence need not to be present in a admissible form at this time, just at trial. So we shouldn't be able.
That is not a correct statement at all, Mr. Oslett. And I didn't see, at least in your second response to defendant's motion for summary judgment that you move for a continuance. Did you move for a continuance?
Well, our trial setting is next year, so.
No, I mean, move for a continuance of the summary judgment hearing to allow you to get additional affidavits.
I mean, I can, I just didn't think that, you know, I have no problem producing affidavits. I just didn't think that it would be able to pass summary judgment, but for the affidavit. I mean, I know the law changed last year as far as the deadline. But I mean, I never requested a continuance if that's what you're asking.
Okay, all right. Did you want to say anything else, Mr. Oslin?
No, just in response, I just, you know, we feel like just based on the no evidence summary judgment, should not be granted because, you know, currently there's more than a scintilla of probative evidence to raise a genuine issue of fact. My client provided that in his affidavit. Discovery is ongoing. Not one deposition has been taken. Trial set in 7 months from now. Negotiations are ongoing. Texas peace officers crash report was provided showing the defendant's breach of his legal duty of care. Medical records, unauthenticated or not, support Mr. Esamoto's breach for being the proximate cause of Mr. Karam's injuries. And there's sufficient evidence to raise a question of material fact. One other thing that I wanted to get into with regards to defense's second response, not pertaining to authentication, is the procedural deficiency of the evidence. It was filed last Monday, 7 days before trial or our hearing. So I'm not exactly sure how there's a procedural deficiency pertaining to that. But other than that, I feel like, you know, summary judgment, no evidence summary judgment motion should not be granted.
All right, so I guess focus on the summary judgment evidence you attached, Mr. Collins, wasn't until within the last 7 days. Is that right?
Your Honor, I haven't attached any documents to my response. The procedural defect is if he's going to use discovery documents, he has to file a notice of intent to do so. He filed the response 7 days, but Judge, if you go back and look at the affidavit that he's trying to use, that's a different objection where I don't want to get bogged down in the weeds on the summary judgment. Again, for appellate purposes, I got to make sure I get the objections right. I'm not trying to be anal about it. I'm sorry, Judge. I messed this up once before. I don't want to do it again. So you've got on the medical records, you've got objections to both form and substance on the grounds that they're unauthenticated. I would point out that in plaintiff's response, he cites the federal rules of civil procedure, not the Texas rules of civil procedure. In the case that he cites is a federal case, not a state case. The law is still good on that, and so I think the objections are valid. And so I would ask that the objections as to those all of the unauthenticated documents, the crash report, the photos, and the medical and billing records, those objections be sustained based on those grounds.
All right, I'm going to sustain the objections to the plaintiffs, all the evidence attached to the plaintiff's motion for summary judgment, with the exception of the affidavit of the plaintiff.
All right, and then in regards to the affidavit, Your Honor, I would point out, if you go back and look at the date on that, the affidavit was dated, I believe, August 19th. I don't have it on my computer, but I was just looking at that, and that was Friday. And I believe the response was filed at like midnight or 11 o'clock. And so I would object to that affidavit as untimely. And I'll be honest with Your Honor. If that's dispositive of it, I mean, it's a self-serving affidavit. I didn't brief that in the reply because that was before this was filed. And so if the court finds the affidavit dispositive on any issues other than the fact that it wasn't produced in response to the original response to summary judgment, I'd like the opportunity to brief on that. But I think it's objectionable because it wasn't timely produced as an exhibit in his response to the summary judgment 7 days before the hearing. Rather, it was produced Friday night. I believe it was filed. I think it was filed. I'm not sure what time it was filed, but it was filed Friday.
Mr. Oslett, did you file a motion for leave to supplement the summary judgment record to add your client's affidavit?
Not yet. I can. We've been trying to negotiate this file, so I mean, I can do that. I don't have a problem doing that. It's just this is the first no evidence summary judgment in an auto accident that I've had without a deposition yet. So I felt like the facts were clear to be able to.
Mr. Oslett, in the future, just I'm not trying to give you a hard time, but if you're ever in this situation again, you should move.
File a motion for leave. I've done it on one of my
File a
cases.
motion for leave to supplement the summary judgment record. You also should file a motion for continuance to request additional time to get affidavits, because it's perfectly reasonable to request additional time to get the medical record affidavits. You just didn't do any of that stuff. And so
Yeah.
as a judge, I don't really want to grant a summary judgment on this, but it puts me in a difficult position because you haven't followed the procedural rules you're supposed to in this type of situation. And so,
yeah, and I've done it last minute. I just didn't really want to, I guess, waste the court's time since the hearing was today, and file a leave and have to have this, pushed back. So, I mean, I can file a continuance on this. We were trying to, the defense and I were trying to get this resolved, and, it just kind of crept up on us this day.
It didn't creep up on me, Judge. And Your Honor, just in response to that, again, think about the prejudice to my client now if you deny if you know what I mean? Like, he says there hasn't been any discovery or depositions. That's on him, right? I mean, that's not my burden. And so he's already filed one motion for continuance. The accident happened in 2019, so it's not like any of this should have come as a surprise. And so, I mean, it's not a timely affidavit. And I'm sure if the court gave me opportunity to brief on it, I would find arguments that it's objectionable. It just wasn't timely filed. And so I didn't have the opportunity to brief it, before the hearing today. And so based on the court sustaining of all of the other exhibits, all we have left is this affidavit. And so you've got the form defect related to the timeliness of it. And then if the court isn't convinced by that, I would ask the court to give me leave to file a response to show the court the substantive defects in it. But I think I've shown enough to the court just on these objections to get me there.
I'm not I mean, Mr. Oslett,
In response to that, I mean, we've had one continuance filed. I don't know how it is in Dallas County, but in Harris County, everything from 2016 to 19 is being tried this year. And so, I mean, we're midway through discovery. My client hasn't been deposed I haven't deposed their client or Walmart. It just seems premature to grant a summary judgment this early in this file.
I would tell you I normally wouldn't, but yeah. you just didn't follow the procedure. That's the problem. Mm-hmm. Well, Mr. Collins, why don't you do this? Why don't you file I'll give you time to brief the issue of whether or not that affidavit should be struck. And then in the interim, why don't you guys see if you can't get this case settled?
Thank you, Judge. I'll get that on file immediately.
Mr. Oslett, just try to.
No, I'll be more diligent with regards to it. It's just we got this. This was filed on a 2-week vacation in July, and along with a motion to compel, which I believe we're supposed to hear today. Or did you pass that, Mr. Collins?
Well, Your Honor, since we're here and on it, just the one issue that I would like, regardless, I think I'm there on the summary judgment. But if the court finds otherwise, the plaintiff hasn't produced any information regarding the plaintiff's employer or employment. He said it's not relevant because he's not making a claim for wages. I say it's still relevant because he's making claims for past and future physical pain and physical impairment. So I would believe I'm entitled to information regarding his employer and his employment history since the accident.
Mr. Oslot,
We amended a petition on Friday to discount that. Those
discount
damages.
what?
Discount the damage that he was talking about, the impairment.
So there is no impairment claim?
We took out lost wages, loss of future earnings. He cut in and out. Did he say impairment?
He said impairment.
Okay, I can take out impairment if he wants that out too. Mr. Collins.
Well,
You
if you
just
take out
didn't- you
impairment.
didn't bring it up to me.
I agree with Mr. Oslot. If you take out impairment, then there's absolutely no basis to go into the employment history. So
If you'll take out past and future physical pain and physical impairment.
physical impairment, not physical pain.
All right, physical impairment, past and future
Wait,
physical.
I'll take out whatever that says impairment on my damages, Mr. Collins.
Any
All right.
impairment, any lost wages, then there's no reason to do employment but he could still make a claim for physical pain and suffering.
All right. And Your Honor, just for final clarification purposes, I'm sorry. At this time, you have sustained defendant's objections to all of the exhibits, but for the affidavit, and you want briefing from me as to the admissibility of Mr. Curram's affidavit, both as to form and substance, and in the interim, you are instructing the parties to try to get the case resolved.
If you can, yeah.
All right, very good, Judge.
Thank you, guys. Get me an order, Mr. Collins. The order at the beginning should say, instead of on this day, that this was heard on August 22nd, 2022. Make sure that you share that with Mr. Oslot as to the things we ruled on today. Mr. Oslot, you need to make sure that your petition takes out impairment as well as
Absolutely.
lost wages and loss of earning capacity, past and future on all of that, and email that to Rhonda as well as e-filing it. You guys have a great rest of your day. Okay.
Thank you.
Your Honor.
All right. Bye-bye.